people? Ready to go? I'll call to order the meeting of the Planning and Economic Development Committee, this being Thursday, April 27th, 2023 at 7 p.m. in the automatic chamber. I'm going to do a dual role multitasking here. So will the clerk please call the roll? Alderman Derek Theobald is absent. Alderman Elijah Ben Clemens, absent. Alderman June Karen
Here.
is here. And Alderman Elijah Michael O'Brien is here. And will be presiding as acting chair. And Alderman Elijah Mel Moran is absent. We have 3 members, and filling in for Alderman Elijah Melbourne Moran will be Alderman at Large Gloria Timmons.
Here.
Okay, and so therefore I will declare a quorum of 3 members. All right. I'm going to open up the public hearing on ordinance 23-47, amending the land use code regarding the minor site plan amendments to permit seasonal outdoor dining approvals. I still am not done, Alderman Jettie. This is a public hearing, so therefore the people speak. I'll open up for testimony in favor. If somebody comes up to speak, can you please give your name and your address, and you'll have time to speak. Okay, is there anybody that wants to offer testimony in favor? Seeing no one, I'll close the testimony in favor and then open up the testimony in opposition. Does anybody want to come forward and offer testimony in opposition? Seeing none, I'll close the opposition portion and open up again testimony in favor. Anybody willing? And seeing no one, I will close the testimony in favor and open up testimony in opposition. Seeing no one has come forward in opposition, the public hearing on O-2347, I will declare closed at 7:04 p.m. Alderman Jettie, you had your hand up?
Yes, thank you, Mr. Chairman. It's just normally our custom to acknowledge aldermen who aren't on the committee but who are in attendance.
I think we could do that. I'm multitasking here. You got to be a little bit
I was
gracious.
just trying to help you out, that's all.
All right, we'll clean this up. Alderman Jettie. And Alderman Dowd. And Alderman Como. Thank you. And also in attendance is Matt Sullivan of the City Economic Development.
No.
Community development.
Community development.
Community Development.
No additional titles needed.
Are you sure?
I'm okay.
Did I give you a promotion? Okay. Back to
No
the
comment.
agenda. We'll open up the hearing of ordinance 2351.
Thank you.
Amending the land use code regarding the application of the sign article to governmental signage and the approval of sign permits through the site plan review process. Same rules as before to the public. I'll open up testimony in favor. Seeing none, I'll close the testimony in favor. And open up the testimony in opposition. Seeing none, I'll close the testimony in opposition, open up testimony in favor. Seeing none, I'll close the testimony in favor and open it up for testimony in opposition. Seeing none, I will close the public hearing on O-2351 at 7:06 p.m. And I did open it up on the testimony and ordinance 23-051 at 7:05 for the record. Okay, I will now convene the regular meeting open at 7:06 p.m. Again, with roll call, Alderman Karen,
Here.
Alderman O'Brien is present, and Alderman Timmons
Here.
is here. Also in attendance is Alderman Jettie, Alderman Dowd, Alderman Como, and Mr. Matt Sullivan. Okay, I will now open up this meeting for public comments for items being discussed on the agenda. Seeing nobody coming forward for public comment, I'll close the public comment portion. Communications, there is none. Unfinished business resolutions, unfinished business. We have ordinance 23-047 as amended, amending the land use code regarding the minor site plan amendments to permit seasonal outdoor dining approvals. Anybody would like to make the motion?
I'd like to make the motion, Chairman, to approve, for final approval of, O-23-047, amending the land use code regarding minor site plan amendment to permit seasonal outdoor dining approvals.
Okay, I didn't really get that, no.
Final approval
Yes,
for O-23-047, amending the land use code regarding minor site plan amendments to permit seasonal outdoor dining approval.
thank you for repeating. I've lost one hearing aid. I'm only down to one, so please bear with me. Thank you so much. Alderman Como.
Thank you, Mr. Chair. So I'm not on this committee, so I can't make any motions, but I did speak with Chairman Moran the other day, and this came up in the full Board of Aldermen meeting the last time we met, and we voted to re-refer it to this committee so that we could have a deeper discussion about it. And seeing as how 3 of the 5 members of the committee aren't here tonight, I was hoping that a member of this committee would make a motion on my behalf to table it until those missing members came back. Alderman Moran was in supportive of that idea, but like I said, I can't make the motion, so I'm hoping that one of the 3 of you will make that motion on my behalf. Thank you.
Okay, yeah, motion would have to be made by a member of the committee. But however, please indulge, I would like to recognize Mr. Sullivan to introduce this, discuss it briefly, and would tabling greatly affect, aren't we kind of under the gun with any time limits with this?
Mr. Chair, Matt Sullivan, Community Development Division Director. I'll start with your second question and respond to that. One of the unique facets of land use law in the state of New Hampshire, and don't worry, I won't be giving a big missive here, but is that once a section of zoning is posted for public hearing, that zoning is actually in effect until the decision-making body makes its final decision. This is an extremely interesting oddity with within New Hampshire state law. And so to that end, this zoning that has been notified for public hearing is in effect as law right now. And so businesses could apply currently for the under the $25 fee that's been proposed here and secure an outdoor dining permit to operate at this point in time. So to that end, timeliness is not critical. However, that timeliness does create an uncertainty in the event that the Board of Aldermen do not vote to approve this legislation, and could create a condition where the city may have to take an enforcement action and actually pull back approvals that it's granted during this sort of uncertain time where the legislation has been in effect as law. So timeliness is not critically important for entities that were to apply now, but it could impact the outdoor dining season that we expect will begin in earnest at any time over the coming weeks as weather conditions improve. However, I would say it's more important for me as the implementer of this ordinance to have clear guidance from this committee and the Board of Aldermen on the direction moving forward. And so I certainly would not propose, or I would not support the tabling, but I would accept it in the interest of achieving a better outcome through the land use code or through the ordinance itself. And I think that's a shared objective of this committee and the Board of Aldermen as well. But I do want to be clear that today, the Community Development Division and the Planning Department directly could issue approvals under the posted ordinance that's been posted for public hearing.
Okay, Chair does have a question on that. If this were to go through without tabling, this ordinance can be open for future amendments in the future, correct?
That is absolutely correct.
So at the next meeting of PEDC, if they should choose and bring this up on the agenda, the new ideas or any other implications that they want to bring up can be amended into the process, correct?
The answer is actually no, in the
Okay.
sense that another oddity of New Hampshire land use law is that when a public hearing is held on a piece of land use legislation specifically, if any substantive changes are made to that proposed ordinance, a new public hearing must be held. And so unlike other legislation that the Board of Aldermen deal with, any change to this that takes place, whether that be at the Board of Aldermen level or even at this committee level, will require notification of a new public hearing and this process that we're going through this evening. And so amendments are just not as simple when it comes to land use regulations within the state of New Hampshire.
Thank you for your clarification.
Of course.
I'll open up discussion on the board to which what we want to do. Alderman Karen.
Yes, thank you. So this was brought up before, and there was a lot of discussion because on the books, it was a $300 fee, but basically it was for something that was more permanent than something that's only there for 3 or 4 months at a time. And we had that discussion that maybe it shouldn't be $0, but it shouldn't be $300. So we asked you, I think the committee asked you to look at a good compromise as to between $25 and $50. And that's what this amendment is for. So the thing is, if we table this, and in the meantime, people come in and ask for an application and you're charging them $25, and down the road, the committee takes it back and says, no, we're gonna charge $300, maybe those people don't wanna pay that $300. So now you're adding more work, talk about staff work, to undo this. I just don't think that's fair, and no offense to anyone who's not here, but we knew this was coming up, so, you know, I think it's important for these people who are doing this on their private property to have the capability of be able to do the outdoor dining or whatever it is within their, starting the 1st of May. I mean, we already see that downtown has their tables out on Main Street, and they're not part of this, so I just don't think it's fair. I just feel that we should move this forward. And if they decide as the full board to dump it again, well, that's fine too, but I think this committee should put it through and pass it and see what happens. I don't think everybody on the Board of Aldermen is looking at a $300 fee every year for permitting of a short-term idea. So, but I am in favor of moving this forward, not to table. Thank you.
Okay. Further discussion, Alderman Jettie.
Thank you, Mr. Chairman. So I would like, you know, again, I'm not on the committee, and, you know, it's nice since a motion hasn't been made to table, it's nice to be able to talk about it. So I just want to, I would be in favor of tabling it, and let me explain my reasons. At the last, I can't remember if it was the PEDC meeting or the Board of Aldermen meeting, but when it was, when the discussion was had about referring it back to the committee, and the committee asked Director Sullivan to look into, a compromise. After that meeting, he and I and Chairman Moran spoke about this, and Mr. Sullivan and I agreed that we would meet and talk and see if we could come up with some language that we could agree upon to propose to the committee. As you all know, Mr. Sullivan's a very busy guy, and he and I could not meet until the Friday before the meeting. That Friday, I happened to be ill, and Mr. Sullivan recognized that and said, let's not do this today, let's do it next week. Both of us forgetting that there was a meeting on that following Monday, and we agreed to meet on Tuesday. And then on Tuesday, I found out, and Mr. Sullivan, I think he called me either Monday night or Tuesday saying, hey, we had the meeting Monday night, and I don't mean to mischaracterize anything, but Mr. Sullivan said, I was caught by surprise. I said $25, and that's what passed. And when we talked about this, Mr. Sullivan, we talked about the fact that, these minor site plan amendments, have in the past carried a fee of $300. Chairman Moran had said that he thought it was fair to charge, a fee for the first review that would be more substantial, maybe the $300. I don't remember exactly if he said that or not, but he was looking for a larger fee for the first time, and then these annual reviews would be at a lesser amount. When I talked to Mr. Sullivan, I said, what exactly do you do? It kind of concerns me that people just come in, with a site plan review, and they say this is what we're doing, and we don't follow up. We don't check on that. And he said, no, we absolutely do. We go out and inspect to make sure they're doing what they say they're doing. And I said, gee, the minute you send someone out there to do an inspection, the normal fee for inspections on our fee schedule is $100. So, why would we be charging, $25, when it's, you put somebody in a car, drive out to a location and look at it and come back to the office? I mean, it just, personally, I don't want to gouge people, but I think we ought to get paid for the service that we're providing. I think it would be good if you tabled it so that further discussion could be had. But if you want to go ahead, then I won't support $25. It just seems unreasonable. We charge $100. Every inspection we charge $100. So I would be in favor of an initial site plan review fee for the first time, and then for the annual review, charge something a lot less, but if you're gonna go out and inspect, at least charge the inspection fee.
Alderman Karen.
Okay. May I ask a question?
Absolutely.
Thank you. Director
Yes.
Sullivan, thank you. So how many of these applications have been putting in for this particular permit over the last 5 years? I know pre-pandemic might have been different than now, but, and what was the fee that we charged?
Mr. Sullivan.
Thank you, Mr. Chair. It's important to identify the fact that this type of outdoor dining approval was only issued beginning in the first year of COVID. And so we have only those years of data to support this discussion. But I can say that in the sort of peak COVID time, when restaurants were open, we were issuing about 25 in that year. We dropped down to 20. There's sort of been a tailing off down to 20. And subsequently, in this most recent year where we were issuing these, this most recent summer, we issued approximately 11 permits to restaurants through this no-fee permitting process that was in place. So most recent year, 11 permits, no fee. Back in peak COVID, it was about 25 permits that were issued, or approvals, I should say.
Alderman Dow.
Yeah, when it comes to the full board, I'm going to support it for the following reasons. One, on a site plan visit that we charge $100 for, it's for one person or one entity, and it's to their benefit. If we're doing the downtown dining, the people doing the inspection can do probably all 11 in one visit. It's all in the same area. It's not like they have to go all over town. And it's somewhat to the benefit of the people that live in Nashua because they all enjoy outdoor dining. So I would be against tabling it because I think the full board's gonna vote for it. And the other reason is that we're almost in the outdoor dining season. If delaying it is just gonna convolute the entire question. And I think the people that are trying to plan for outdoor dining deserve the right to have this year set up. If we're gonna do changing fees, we ought to do it mid-year, not just before the outdoor dining. So I would be against tabling it.
Alderman Como.
Yes, thank you, Mr. Chair. It was my understanding, and through you to Director Sullivan, you can correct me if I'm wrong, but this was not for the downtown expanded dining. This is for pretty much everywhere else. Is that correct?
Mr. Chair, that is correct. This specific permitting process applies to outdoor dining on private property only, outside of the public right-of-way, just as a clarification. I would just add, though, that the commonality is the imminent need to have some sort of process in place, regardless of whether it's occurring in the public right-of-way or on private property.
Can I follow up, Mr. Chair?
Follow up.
So based on comments you made earlier about the state law regarding land use code and the need to notice public hearings and things like that, that was part of the reason why I wanted to suggest tabling this tonight, was because I'm afraid that this is going to go back to the full board where there was support for a change in the fee structure, and it's going to get re-referred back here for amendments, or there's going to be amendments made at the full board, which are going to require another public hearing. And I thought that the quicker process would just be to table it until we could get it completely right here, and then send it to the full board rather than send it back and forth a couple of more times.
Alderman Karen.
Okay. To that effect, if my understanding is that if we make amendments here, it still has to have another public hearing, no matter what. So we're still delaying this by almost a month.
But we're delaying it more if we make those amendments at the full board.
Follow up?
I think the issue here, and Alderman Dow made the point that we're into dining season. If you want to make changes, carry this out, and then come September, look at it again if you want to make changes, and make changes for next year. You shouldn't be doing this again at the last minute. We felt that as a group, these private entities should be, they're just asking for a permit, and yes, they're going out, but they're not inspecting a whole building. They're looking at it outside to see if they're gonna put the tent up right, or the tables, or whatever it is that they're doing. It's their property. All you're doing is verifying that this is what they're following the application as provided by the planning department. To charge them $300 or $200 is kind of what, it just does not make any sense. You're coming out of COVID and you're gonna go from a nothing to $300. That doesn't make any sense. But I will not agree to a tabling of this piece of legislation. I'm sorry.
Alderman Como.
Thank you, Mr. Chair. Just the last thing I'm gonna say is just to reiterate, I can't make a motion, so there's no tabling this tonight unless one of the three of you make the motion, so it's gonna go to the full board. Full disclosure, I am prepared to make a motion to amend at the full board, and I believe I have support in an amendment, so I was just making the suggestion because I thought it would be quicker, but if there's no appetite from the three of you to do that, then I recognize that its final passage is gonna be recommended and it's gonna move on, so that's not really up for debate. Thank you.
Alderman Timmons.
Thank you. Director Sullivan, having listened to what my colleagues to the left said about tabling it, if we table it and then it comes up, if we don't table it and it comes up on the full board when we have our next meeting, which is, 2 weeks from now, right? At that time, we can make any amendments and still have a public meeting. Is that correct or not?
Director Sullivan.
Mr. Chair, the board can make amendments. That is absolutely correct. What will also have to happen, though, is that the board will have to act that evening to set a new public hearing at a later point in time, subject to the notification requirements under state statute. And what that looks like is there needs to be really 10 days, or I should say 12 days of time between when the public hearing notice goes out to the newspaper and out to any other appropriate parties, and when that public hearing takes place. And so, just walking that through again, if the board makes a motion at its next meeting to amend and re-refers and sets a new public hearing for PEDC at a later time, at a minimum, there will be a 12-day gap between when that happens. Obviously, there's the intricacy of when the PEDC actually meets and all the scheduling associated with that, but it can create substantial scheduling delays. Not that that should influence the decision-making per se.
Alderman Lopez.
Question through the chair to Director Sullivan. Is there a delay period after a public hearing as well before the board can act on it?
There's no such delay after the public hearing that the board cannot act on the legislation.
Okay, just thought I should check both sides.
Sure.
Right, that's why sometimes Alderman Lopez will have an oral report because of the meeting the previous evening. And the chair usually gives an oral report at that particular time. Director Sullivan, anticipated, we don't charge fees to make revenue per se. You know, we do it to fill our, make us whole in regards of city services, being compensated for the time that they do it. But how much of a loss? Right now, we're not charging anything.
Mm-hmm.
And because of the lateness of this with the pending season, I wish this is something we should have discussed, and I'm not gonna blame anybody. This is something we should have discussed in February.
Mm-hmm.
But that has so left a bond right now. So how much anticipated, and I guess would be, would there be a big financial loss if we prepared better for next year?
It's difficult for me to quantify what the loss would be to private businesses if this legislation is not approved. It's impossible, in fact, for me to quantify that. I simply don't know the financial impacts. I would just say for the record, this legislation actually was initially heard in February. And not to sound defensive, but we actually did think we were somewhat ahead of this. But I understand that subsequent amendments were necessary. They were very logical amendments, and so I don't want to criticize any delay that resulted from that process. But we did attempt to get in front of it, and I recognize that we should have done that perhaps in December, really, to allow for this very important conversation to happen. It is just difficult for me, though, to really gauge the impact. I will say this. In the event that this legislation is not approved, or it's delayed such that outdoor dining cannot proceed in some way, shape, or form, we will simply direct restaurants that are particularly interested in doing this to apply for a $300 minor site plan amendment that's currently allowed under the existing ordinance. So there's still a mechanism to allow for the outdoor dining to happen, but the fee is much more substantial, if that makes sense. So there's still a mechanism. It's really a question now of whether or not the fee is commensurate with the request itself.
So what you're saying is if we pass this, an applicant can get by for $25 if we pass it. If we do not pass it until the next modification and public hearing and everything, could be a $300 fee, correct?
That is correct.
Alderman Como.
Thank you. I thought you, Director Sullivan, I thought you said earlier that once we've had the public hearing, the new ordinance is in effect.
Mr. Chair, I'm making the assumption that that the board would not table indefinitely. I'm making the assumption that there would be an action to vote against the proposed legislation.
Mm-hmm.
If the board tables indefinitely, and this may be something that requires some legal consultation, if the board tables indefinitely, I believe there is a sunsetting of the posted legislation. I can't answer the question as to when that would be. I do not believe if a vote to table indefinitely is made or something similar, I do not believe the legislation remains in effect. I think that would be something we'd have to explore with the legal department. That's a good question.
Alderman Como.
Yeah, I don't think that tabling indefinitely was something that was in play. I feel like me specifically, we're just looking for some more time to haggle, for lack of a better term.
Sure.
So if we tabled this tonight and people could apply for $25 a permit, and then the final version that ends up getting approved was $50 a permit, would you have to go back and collect an additional 25 from anyone who was issued a permit, or would they kind of get it for the 25 because that's what was on the books, and then once the final version was approved, going forward, that's what applicants would be charged?
Director Sullivan.
I'm concerned that if Attorney Bolton were here, he may caution me from answering what I would call
I won't hold you to it.
a legal question. No, but I'm fairly confident in the answer. And the answer I'm fairly confident in is that if an applicant is approved under the ordinance that is legal and in force at the time, it would be permissible for them to extend that permit through the remainder of the outdoor dining season, and we would not collect an additional $25 fee. So I think they would be held to whatever standard existed at the point in time that the application was made. If that standard changes at a later time, that would not be applied to the application.
Okay, thank you. So it sounds like there's no harm, so that's the only reason why I suggested it. Thank you.
Well, Alderman Como, define how you interpret no harm.
Sure. So the current ordinance as amended says that applicants would pay a $25 fee.
Correct.
That's what the legislation before us is. And so if we voted to table this tonight, that is what is in effect, and that's what would be in place, which is no different than if we approved it tonight. So there's no harm in holding it back until the other three missing members of the committee are here that wanted to discuss this in more detail.
Director Sullivan, I see the light bulb above your head.
Well,
But so it's not gonna hold you up from issuing
dimly
permits or
lit
anything
bulb.
either.
I believe the answer to that question is yes. What I need to confirm with Corporation Counsel is if there's a ripeness to that tabling. Because I don't believe that if you were to simply table and I'm not suggesting a table indefinitely motion, but if you were to table to an uncertain time,
It would be the end of the year, would be when it sunsets, the end of the
and so
legislative
it would be
year.
the end of the legislative session. I do want to confirm with Corporation Counsel, but my opinion as of this moment is that because the legislation has been posted for a public hearing, a tabling motion would keep that piece of legislation in effect until such time that the committee or the board directly take it off the table. Therefore, a $25 fee would be applied.
Alderman Dow.
One final thing, I hope. If it's tabled at this committee, at the full board level, it can be taken off the table and addressed at the full board meeting.
Correct. Okay, further comment on ordinance 2347? Okay, seeing none, I will call the roll. Alderman Karen.
What's the motion?
Oh, the motion is for final passage.
Oh, okay, yes.
Alderman Timmons
Yes.
and Alderman O'Brien votes yes. Motion carries. Also before us is ordinance 23-051, amending the land use code regarding the application of a sign article to governmental signage and approval of sign permits through the site plan review process. Alderman Timmons, do you have a motion?
A motion to approve 023-051, amending the land use code regarding the application of the sign article to governmental signage and approval of sign permits through the site plan review process.
Okay, a motion for final passage. Discussion on the motion. Do you want to?
Yes.
Yes, Alderman Timmons.
Yes, thank you, Chair. One of the things about this passage, I don't support it because this particular signage mean that signs or electronic signage is right. And it doesn't belong in a residential area, in my opinion. And I couldn't support this. I wouldn't want this outside my door. So I don't think it's a good idea. However, fixed signing is fine,
Okay,
unless,
before we have, and I think he'll probably answer to that, I think Director Sullivan's got to give us all the particular information. And so I will now turn it, before I take any other questions from members of the board, Director Sullivan.
Thank you, Mr. Chair. And I'm thankful to Alderwoman Timmons for raising that concern because in fact, this is where I was going to end my comments this evening, and you will hear a bit of a missive from me on this particular piece of legislation that's proposed. I want to be very clear that this proposed legislation does not allow expressly any specific sign that is being considered in the city of Nashua. This is simply an amendment to the land use code that suggests an alternative approval process or relief process for signs that do not comply with the city's existing ordinance. So I'm gonna stop there and I'm gonna provide some comments that are more broad in nature to sort of explain the reason that this is being brought forward, the context in which I'm presenting it, and I look forward to questions tonight. And Alderman Jetty and I have had some good dialogue about this already, and I expect this will be a very active discussion tonight about the intent of this change. So I'd like to start with something that folks may not be familiar with, and that is that under New Hampshire state law, under RSA 674-54, for us land use code nerds and attorneys, governmental uses are expressly exempt from their municipal zoning ordinances and regulations. However, many communities, like the city of Nashua, have actually taken the position, and I think it's a very good position, that despite the exemption that state law provides them under their municipal ordinances, they have said, we want to be representative of the general message and character that our zoning ordinance and our land use regulations lay out. And therefore, we will actually opt in to be fully subject to that code that exists and applies to the rest of the community. Again, Nashua has done this. It has acknowledged that the zoning ordinance and the rest of the sections of the land use code are important to it, and it wants to reflect the character included therein. However, This can have its challenges, and this is what I'm going to talk to you about this evening, some of the maybe unintended consequences that I've observed in my time in the Community Development Division with both specific projects and having a larger vision to what I think municipal signage might look like in the future in the community. I've seen some of these things firsthand. And just to be clear, as the ordinance is currently written, the land use code regulations and the sign ordinance particularly apply in full force to any sign that the municipality puts up on its property. The ordinance before you this evening does two fundamental things. One, and this is the not so important piece maybe, but very important for my team, is that it removes an administrative loophole that exists within the ordinance that suggests that any sign that's shown on a site plan that's presented to the planning board, if approved by the planning board, is fully exempt from the sign permitting process within the city of Nashua. This is something that I think has not been taken advantage of by the development community, but has been sort of a weakness or a weakness in the armor that I've seen that we need to correct and could create regulatory issues for us in the future if an applicant wanted to propose something that's grossly out of character but get it approved through a site plan. So we're removing that allowance that exists and would fully subject any sign on a site plan to the traditional zoning ordinance. The second piece, and perhaps more fundamental to the discussion this evening, is to provide an alternative permitting process through the zoning board via what we refer to as a special exception for signs, any governmental sign for a governmental use that does not comply with the underlying zoning ordinance. So I want to dive in a little deep here, and please forgive me as I get into some of the nuts and bolts of the way that our zoning works. Bless you. Currently, and there have been approximately 14 examples of this since 1999, when the municipality proposes a sign that does not comply with the zoning ordinance in one way, shape, or form, whether that's the size, it's the type of sign, it's the location on the property, that sign is asked to go through what's the traditional zoning process, and that is a variance through the Zoning Board of Adjustment. The variance process of the Zoning Board of Adjustment relies on 5 criteria. No, I will not go into each one of them, but they are, I will spare you that, and I think Alderman Jetty and I may discuss this in some detail through the conversation tonight. Those 5 criteria are written in law very broadly in New Hampshire statute, but have been more narrowly defined, although not that well defined, through case law subsequent about the criteria and what they mean. Generally, those criteria are intended to protect public health, safety, welfare, to ensure that the zoning that is intended is being respected despite this sort of exemption that's being required. But one of the criteria that I think is very important to point out in the context of municipal signage is the fact that variances and the approval of a variance requires an applicant demonstrate a level of what they refer to as hardship. I definitely will not be attempting to define that this evening because it's a very deep and well litigated definition. But essentially, there needs to be a very unique circumstance of the property or the application itself that the sign needs to demonstrate, allowing for the zoning board to approve it. Leading me to maybe a more controversial comment. Of the 14 to 15 variances that the city has considered for municipal signage over that 24-year period that I mentioned, nearly all have been granted. I would argue that in many of those cases, hardship was not strictly met and that the zoning board was using a standard of reasonableness, trying to implement the general health, safety, welfare impact, the zoning character impact, but being more careful and reasonable with the hardship standard. And so I'm saying clearly for the record that I believe the municipality and the zoning board has used a different standard of review already for municipal signs that are asked to go get a variance. That gives me concern, however. And so what I'm proposing with this legislation and the legislation that I brought forward with Alderman Dowd's sponsorship is to not take away the need for relief from the zoning ordinance, but to, rather than put it through the variance process that requires that hardship that may or may not exist, and there may be a legitimate government purpose to the sign, to actually put it through what we refer to as a special exception process. The special exception process is not an exemption per se. It is something that is permitted, but subject to certain conditions. And the Zoning Board of Adjustment is charged with measuring whether or not those conditions are met But again, both a variance and a special exception are decided at the same body. There's still a public notification, there's still a public hearing, and there's still an opportunity for the zoning board to say no. Why would they say no for a special exception? Because I think to Alderwoman Timms' concern, when would an application for a special exception as proposed by this ordinance be appropriate or not? The special exception criteria in the city of Nashua speaks specifically to whether or not a proposed application is in accordance with the neighborhood character, the neighborhood integrity, and honors very many of the same standards of public health, safety, welfare that are built into the variance criteria, but not that standard of hardship. So what I'm hoping to drive home here through my explanation of those two different processes is that I believe that putting signage that does not comply with the municipal regulations through a special exception process still provides the public with a reasonable level of involvement and opportunity to object, and does not take away the zoning board's ability to actually deny in the event that the sign is absolutely not appropriate. All that this ordinance does is takes away the need for a sign to actually demonstrate a level of hardship that, in my experience, cannot necessarily be demonstrated, and in my opinion, should not need to be demonstrated for an application or a sign that is intended to serve a legitimate governmental purpose and benefit the public in some way, shape, or form. Now, I wasn't going to speak to this, but I think I should. There's been this question raised of whether or not this legislation is a reaction to any specific proposal that's being considered or proposed in the city. I want to be clear that it is not. I have had conversations with my team and with many folks about this since my arrival here in the city. I came from a community where municipal signage was fully exempted. I'm not saying that's the right approach either, because I don't think it is. But I believe that there should be a process to keep the municipality in check, and that whatever it's implementing is still in accordance with what the neighborhood would like to see. But I do not believe that the municipality should be subject to the same hardship standard if it's acting in the best interest of the public at large. And so I feel an alternative permitting process is more appropriate for municipal signs specifically. My last comment will be simply that I believe there'll be some questions tonight about whether or not governmental signage should be treated in a different way generally. I would point out that the existing zoning ordinance for signs, albeit not included in the information presented to you this evening, already provides for the fact that governmental signs shall be exempt from the permitting process itself. It does not exempt them from the zoning, but it exempts them from the permitting process. And I raise this to say only that governmental signs are already contemplated differently within the context of the sign ordinance. What I'm offering and what I'm suggesting that this committee recommend, and I'm asking for your support, is that these signs be put through an alternative process in cases where they cannot meet the zoning ordinance, but that will still be protected by the Zoning Board of Adjustment in those cases. I'm happy to take any questions that folks may have.
All right,
I
good.
appreciate your indulgence.
At this time, I want to recognize the prime sponsor of Ordinance 51, and Alderman Dow.
Yes, the reason for this action is to make it a little more streamlined, to provide signage to the general public, to give them the information that they need. We get beat up left and right all the time that we're not providing enough information to the public on what's going on. I believe this will also fall into the authorizing the, if you've seen the orange signs on the carts from the Board of Public Works that, advertise police examinations, hazards, hiring, a number of things that we use them all the time. Events coming up that are all public information and are beneficial to the public. What Mr. Sullivan is saying is to put those through this process as it currently exists for variance. It costs the city money, costs the zoning board more time than it should, and discussion on hardship and everything, which takes forever because, again, nobody can define hardship. And to me, the hardship would be that we are not providing the public information that we should be providing. So this ordinance is as Director Sullivan explained, and I fully support, this, because the signs that we've been discussing, the signs that are applicable here, are providing public information that the public requires and should have. And to do anything to detract from that just exacerbates the fact that we're not providing enough information to the public on what's going on in city government or in dangers or the other things that I mentioned. So I hope that the committee will endorse this because it's in the benefit of the city and, more importantly, the general public. And as he said, 15 signs in 24 years that have gone through the process for a variance, even though it took forever, were all approved. So let's make this a little easier for the planning department to authorize signs that are going to provide information to the public that they need.
Okay, I know Alderman Como, I see your hand, I will recognize you, but I'm gonna go with burning desires from members of the committee. Alderwoman Timmons.
Oh, thank you. To my distinguished colleague over there, Alderman Dow, those signs that you are talking about, temporary signs, is that correct? That that the city does provide, such as the police exams are coming up on whatever day. So they're out there and we see it, the public see it. Those are temporary signs. But I'm not talking about a temporary sign. I'm talking about the permanent signs that the public may not need to see that all the time. The school signs, for instance, I'm going to take the schools. The schools all have their little stationery, and we know what's going on in schools because they post everything on their stationary signs. So what is going to enhance the public for knowing more information by having a different type of sign?
I think I defer to Director Sullivan to talk about the signs that are permanent in place that are informative to the people. Those are also under consideration.
I may, Mr. Chair.
Director
Just to
Sullivan.
provide a clarifying comment. So the orange public safety signs, if you will, if everyone understands what I'm talking about, that are on trailers,
Yeah.
those are not something that will be affected by this. And the reason for that is that those are within the public right-of-way. And items or signage within the public right-of-way is governed under a different set of regulations. These apply only to, I'll say, private property, but also, public parcels of land that are owned. These standards apply. So those temporary movable signs, as long as they're contained within the right-of-way, those are not impacted specifically by this ordinance. Those are allowed or permitted through another process. But I again want to maybe caution the committee. Electronic messaging signage, where it is not approved, will still be subject to zoning board relief and approval in areas where it's not approved. The difference and the modification that this ordinance proposes is simply that if an electronic messaging sign is brought forward by a school or the municipality, the zoning board will use a different set of criteria to decide whether or not that sign is approved. Now, I would offer that I believe one of those criteria, the special exception criteria that I'm proposing, are easier to satisfy, but I would argue that the underlying intent of those criteria is exactly the same as the variance criteria. And I also believe that the zoning board could deny an application that it feels is inappropriate based on those criteria as well. So it's really a change just of process. This would not allow for an electronic messaging sign in an area where it's not already allowed. It just sets forward a different process for getting an approval to put that kind of sign in.
Okay, committee members all set? Okay, Alderman Como.
Yes, thank you, Mr. Chair. Through you to Director Sullivan, I was just curious, you mentioned there were, I might get the numbers wrong, but 14 over the last 24 years have been granted this variance. Could you just give me like an example or two so I know what type of signs we're talking about? You don't have to go through the whole list, just
Yeah.
maybe the one I might be most familiar with if I drive by it or something.
That's a good question. Yes, I'll give you an example. I think one that everyone will know. The Hunt Building. There's currently a ground sign that encroaches into the front setback for the Hunt Building.
Yeah.
And it also has manually changing text on the reader board, which is not permitted by the zoning ordinance or was not permitted at the time that this variance was approved. So again, that sign went too far into the front setback, closer to the right of way, and to actually have manually changing text, that also required a variance as well.
Okay.
And that's a Hunt Building sign.
I was just trying to picture in my head what
Yep.
exactly we were talking about, so thank you.
Absolutely.
Can I have a follow-up to that?
Yeah.
Yeah, that is a low-hanging fruit sign. Give me one that's not so low-hanging that we know of.
Okay. Let's see. Trying to think of one that everyone will be familiar with. The Elm Street Middle School. The Elm Street Middle School in 2014 had a variance approved for ground sign height, as well as a variance approved to allow manually changing text on the reader board. I mean, none of these examples are particularly impactful that you'll say, oh my gosh, that was an egregious overstep of the regulations. And I think that's part of the point of my bringing this forward, where there are reasonable allowances that can be made if there's a case to be brought forward. And I think the zoning board has used that standard of reasonableness in taking these actions in the past. My concern is that it's critical for the zoning board to act in a way that appropriately applies that fifth criteria related to hardship. And I simply do not think that should be applied in cases where it has a governmental use behind it, I guess, is my point.
Alderman Lopez.
Regarding the first cross-out on the amendment, signs that are included in the site plan, are there any site plans that we're aware of that we may have put forth that actually have signs included? Like, was there any for the Brian McCarthy Middle School or the police station or any known government buildings where we could put a sign that we had approved because it was in the site plan?
Director Sullivan.
What I can speak to is that we're not aware of any situations, and I'll answer your question maybe a bit indirectly and then come back. I'm not aware of any situations where an approved site plan was used to leverage city staff to approve a sign that was not otherwise allowed by the zoning code. What I can say is that on the middle school, for example, or any other commercial site plan, we require signage locations to be shown on the plan anyway. What we don't see typically with the site plan is what the dimensions will be, what the typology of the sign will be. And so for that reason, we've generally protected ourselves against any sort of slipping in of something that might not be appropriate. So I'm not aware of any issues where this has come up or we've permitted a sign. But I tend to believe with these types of things and these types of openings in an ordinance, it's a matter of time before somebody will find it and attempt to leverage it. And so I think we have an obligation to close these as they become aware to it or become.
Follow-up?
Yes, please. So we're not in charge of and actually I guess Alderman Dowd could probably weigh in this. We're not in charge of the school property. So like Franklin Street, for example, where we said, hey, we're gonna put a sign up. They're not gonna put a giant billboard up now because there's a space for a sign, right? That wouldn't be something that a different body could do and then we'd be like, I guess that happened.
It's true.
Director Sullivan.
That is correct. The school department is fully subject to all of the regulations within the sign ordinance. Hence the reason that as I look at these, approximately 4 of these requests are related to are related to school signage that were granted in the past. So they've had some instances where they could not comply with the ordinance and they've had to seek relief through the zoning board.
But to clarify that.
Follow-up?
Sorry, Chair, thank you, please. To clarify that first strikeout where signs can be updated and amended, we would also be closing the way that we would be able to update our own signage. Another example, maybe a little less complicated than the schools, would be the one in front of City Hall. It's a sign. Does that mean we're closing our own ability to update it?
Director Sullivan.
No, it does not. We're absolutely it's absolutely acceptable for any entity, not necessarily being the city or the school district, to update the copy on an existing sign or update the sign in some way, shape, or form. What that sort of more minor striking would do is that if the city were to submit a new site plan for a facility, and on that site plan, it said that we're putting in a 100-foot by 100-foot electronic messaging sign showing the temperature, they could not have it approved through a site plan process. They would have to come and get hopefully a special exception, if not a variance for that kind of signage. I think I'm getting a bit technical, but I hope that's clear.
I understand, thank you.
I think we had Alderman Dowd's hand up.
Yeah, first question is, the sign you were talking about on Elm Street, is that the one for the Keefe Auditorium?
Alderman Dowd, I can't actually answer that question. It doesn't say specifically what the use was for.
Because if it doesn't, the Keefe Auditorium has a sign it's the city sign.
I think there's
It
only
does
one there.
It does not say,
It's only
yeah.
one.
Pretty
I'm
sure
sorry.
it's that only one.
Yep.
And the Pennachuck Middle School, the sign was replaced to replace the old one that was there. So, and that was approved by the site plan. And the McCarthy School, which has a sign on Buck Meadow, was also approved in the site plan, which got full review by your department, and then was approved by the planning board. It may have been zoning board, I'm not sure, but I know we went to the zoning board for some things, particularly the hiberniculum. But there are signs, and you know, like if we built a school, like the McCarthy School, and didn't put a sign up to say where it is, seriously? Does that make sense? So this is just making the process a little smoother. And it's not taking away any of the protections that are offered by zoning. So I would recommend that we pass this.
Okay, Alderman Como.
Yes, thank you, Mr. Chair. I just wanted to thank Director Sullivan for the explanation. That was a lot of information, admittedly, more information about signs than I ever thought I would know or needed to know. But particularly where you talked about the hardship in the existing variance process, you know, the way you explained it, it makes total sense to me. The city in the past has been arguing pretty much against itself for a hardship that may not necessarily exist, and we've been granting it because we agree that the sign might be necessary. But I like that I forget the exact word you used, but there's a public need as opposed to a hardship. And so therefore, I like the idea that we have the correct criteria, that when we're going to do something like this, we're arguing for the correct reason as opposed to just the one that happens to be on the books. So for that reason, when this does get to the full board, I'll support it.
Okay, Alderman Jettie.
Thank you, Mr. Chairman. So, you know, I'm against this. The city, a long time ago, you know, the current zoning law goes back to 2005. I don't know if before that, it also contained the language making the zoning, the land use code applicable to everyone, including the city. I don't know if the language was, you know, was before 2005, but at least since 2005, you know, that was, you know, that's been the law. That was intentional on the part of the alderman at the time. And I kind of have a vague memory of there being, you know, abuses, you know, where the city would, you know, do things that would, you know, be not in conformance with the zoning law. And the alderman at the time wanted to put a stop to that, and that's why we have the language we have now. So, you know, for example, you know, I represent Ward 5. Ward 5 is almost entirely residential. And, you know, and there, as far as signs are concerned, there are, you know, restrictions on what types of signs, can be, are allowed in residential districts. The size of the sign, the height of the sign, the area, the square footage of the sign. Whether it's, lit exteriorly or interiorly, whether the lights can be, flashing. Electronic messaging signs, are not permitted in residential areas. And, for example, and when you think about it, I think it makes good sense. I don't think anybody would want an electronic messaging sign with graphics, flashing lights across the street from their home. And so, they're not permitted in residential areas. And, this all kind of hits home to me because, we just built a new Department of Public Works building. And there was a proposal to put a sign at the entrance of that building to identify where the building is, and so people know where it is. Now, under the existing zoning ordinance, identification signs are permitted in residential areas, and they can be 12 square feet and 8 feet high, and they can be lit exteriorly. Now, that's a pretty substantial sign. I can't imagine that you would need, any more than that to identify where this building is. The landfill has a sign. It's a very nice sign. It's made out of granite. It's not lit. It's not an electronic messaging sign. It's just a very nice sign that complies with the sign ordinance. Nobody has any problem finding where the landfill is. They've been going there for years. They're still going there. But the Department of Public Works requested that the sign identifying this new Public Works building be, of a size, much larger than what is permitted. What's permitted is 12 square feet. The sign they want is 105 square feet. It's huge. And height is 8 feet. The sign they want is close to 10 feet high. And they want an electronic messaging component to it. The electronic messaging is 40 square feet. It's a little TV screen, 40 square feet. And so, the zoning ordinance does not permit that. But that didn't stop them. They voted to go ahead with this sign, to seek a variance. Now, to my viewpoint, the city should not be asking the zoning board to grant variances to violate the zoning law. Of all people, the city ought to be complying with the zoning law. The zoning law, is passed by the Board of Aldermen, saying, specifically for signs, what kind of signs are permitted, what size, what the nature is in the various zones of the city. And to request a variance is an admission that what you want, violates the law, and you want to be relieved from the law in order to do what you want to do. Now, there's a special situation regarding this Board of Public Works building, in that the land on which this sign would be constructed It was part of 4 lots that were purchased by the city some time ago. And the resolution authorizing the purchase of these lots included language that said, and the purpose of buying these lots was to provide a buffer between West Hollis Street and the landfill. And the language of the resolution added that nothing would be built on these 4 lots that did not conform to the zoning law for that residential area. So I pointed that out to the committee, but the committee went ahead and voted to seek a variance for this sign. And it was only because Attorney Bolton sent an email saying that requesting a variance isn't enough because this resolution prohibits a sign that does not comply with the zoning law. Now, the effect, whether it's intended or unintended, the unintended consequence of this proposed revision to the ordinance would, instead of the sign, this electronic messaging sign being not permitted, it would be permitted by special exception. Any sign that the city wants to put in, as long as it's for some governmental purpose, which is pretty loose language, would be permitted by special exception. So it doesn't matter what the zoning law says about signs. The city can request any sign in any part of the city, any residential neighborhood, by special exception. So it's true that in order to get a special exception, you gotta go before the zoning board, but it's a completely different set of standards. As Director Sullivan pointed out, to get a variance, you have to, there are 5 criteria, one of which is hardship. And hardship means that there's something unique about your particular piece of property that is different than all the other properties in the neighborhood, that makes the application of the zoning law unfair, unreasonable to you. It makes it impossible for you to make reasonable use of your property and still comply with the zoning ordinance. So the variance process is like a relief valve to avoid somebody not being able to use their property in a reasonable manner because of the particular nature of the property. The fact that the zoning board struggles with this, is, I think, it's a problem of educating the zoning board as to what that standard really means. When the zoning board says, we're going to grant this variance, even though there's no hardship, we're going to grant it because we think it's reasonable, they're substituting their opinion about what the zoning law is for that of the Board of Aldermen. The Board of Aldermen passes the zoning law. If the zoning law says the sign can only be 12 square feet, the Zoning Board of Adjustment should not say, a 14 square foot sign sounds reasonable to us, we're gonna permit this. Or a 20 square foot sign, it's for a good purpose. It's going to provide information, No, if the Board of Aldermen has said in a residential area, no electronic messaging signs, and the sign can only be 12 square feet, that's what it ought to be. And the zoning board shouldn't, be, if they are ignoring the hardship requirement, then that's wrong. And they ought to, I would ask Director Sullivan to, ask them to, there are courses that are offered to explain this stuff to them, and they ought to be reminded, that they should be complying with the law. There is, people who are, who disagree with the zoning board can, file for an appeal, but, you have to hire a lawyer, that's expensive. Most people don't wanna, don't have that kind of discretionary income to fight the zoning board in court. And, the court is very limited. It's not like the court looks at the decision and says, oh, that was wrong, we're gonna substitute our decision, this is the right decision. The court is very limited as to what it can do. It assumes that the facts are however the zoning board found those facts. They don't question the facts. So if you look at these decisions that Director Sullivan referred to, you will see that the court says, we have very limited ability to change anything that the zoning board did. To change this to a special exception, would make it, make these signs, permitted as opposed to not permitted by special exception. So it kind of changes that resolution where the Board of Aldermen said, these 4 properties, you can't build anything on there that doesn't comply with the zoning law. All of a sudden, the argument is going to be made, well, it does comply with the zoning law because it's permitted by special exception. I think we're making a big mistake. I think, I think of the guy who lives across the street from where this sign is proposed. His name is John Hilliard. He and his wife live right across the street from this thing. They've got a house, it's got a picture window. Picture windows right into their living room. If an electronic messaging sign is permitted across the street, they're gonna have that thing flashing right into their living room. And, when this, when that property was purchased, the argument was made that by the alderman at the time, one of which was Alderman Jim Donchis, said that they don't want to encourage or permit the commercialization of West Hollis Street. It's a residential area. It's bad enough that it serves, as an arterial road, from, people coming from Hollis and elsewhere, down that road, there's a lot of traffic. They've had to live with that, but to allow, the signage that this, to remove the signage from that, the hardship requirement is really opening the door. The zoning board has denied electronic messaging signs on West Hollis Street to people because they could not satisfy the hardship requirement. If we allow this to happen, well, there's going to be a whole number of people that are going to come and ask the zoning board, hey, you let the city do it, let us do it. I think it's a big mistake. If the zoning board, as Director Sullivan says, is trying to find ways around the hardship requirement by imposing a reasonableness standard, substituting a reasonableness standard, which is not what the law says, in order to allow signs that they think would have some value. Think of how they're going to treat it when it's just a special exception and hardship is removed from the equation. The only standard then would be that it not be, should not, will not impair the integrity or be out of character with the district or immediate neighborhood or be detrimental to the health, morals, or welfare of residents. You know, that sounds, like Director Sullivan says, hey, that means that they can't put a sign that's gonna be out of character with the neighborhood. Well, I tell you, if you follow the zoning board, you know, you'll see that, you know, this is language like under the current variance standard, not contrary to the public interest. You know, they just flip over that, you know, they never even discuss it. They just say, yes, we find it's not contrary to the public interest. That's such a, you know, that opens such a, you know, it's such a wide, you know, open door that, you know, that I think is going to be misused. You know, I think that, you know, our zoning law should apply to everyone. If you think that this zoning law is too restrictive, you can look at changing the zoning law. We're in the process of changing our zoning law. And, you know, there are gonna be substantial changes to it that are coming up. And, you know, if you feel that, you know, that we ought to allow bigger signs or electronic messaging signs, you know, we can have that discussion. But, you know, don't do it this way. I mean, I don't know about how you feel about your neighborhood, but I don't want my neighborhood, I don't want West Hollis Street turning into Daniel Webster Highway or Amherst Street, you know, where you can see these signs, you know, with all kinds of graphics, all kinds of flashing, all kinds of colors. It's just not right. And, you know, if you pass this, you know, the Board of Public Works is gonna push forward with this sign that they want. And I know that's not the purpose that Director Sullivan is proposing this, but I think he will admit that that is an unintended consequence that could occur. And so, you know, I ask the committee not, you know, the first part, the part about eliminating you know, signs clearly shown on the site plan approved by the planning board, I think that, you know, that's a good thing, and that would be a good thing to do. But municipal government signs, you know, I would ask you to please vote against that.
Thank you, Alderman. Director Sullivan?
I'd like to just provide a few, what I hope are objective comments in response to Alderman Jetti's comments, and I appreciate his thought on this. He and I have had some dialogue, and I certainly understand we're perhaps looking at this in a different way, and I understand his concern about, I'm not putting these words in his mouth by any means, but the idea of bad faith acting on the municipality, that is something that's real. And I think that the ordinance that's in place today that subjects the municipality fully to all of the provisions of the zoning ordinance was a direct response to some bad faith acting on behalf of the city perhaps in the past. I'd like to think we've moved past that, and I again want to acknowledge the fact that while I appreciate several comments made here that attribute this change or have sort of contextualized it in the context of the DPW sign, and I understand that helps identify what this proposed change will do. What's in front of this committee is a procedural change only. It is not a change to dimensional standards, it's not a change to typology standards, it's not a change to any other specific provision of the sign ordinance that immediately impacts what type or manner of signage is allowed. I do acknowledge Alderman Jetti's comments, and I can completely understand that the argument is that while it's not doing that, it inherently weakens the Zoning Board of Adjustment's ability to regulate the provisions that do exist right now. And so I certainly think that's a reasonable concern to have. But again, I would hearken back to the fact that this is a procedural amendment. I would also just offer that as planners, and the way I've been educated, we are supposed to be constantly monitoring provisions of the zoning code that frequently appear in front of the Zoning Board of Adjustment through variances. And the reason that we do that is if something is going to the zoning board on a relatively consistent basis, we're taught to look at what that code says and whether or not there should be an adjustment to it. What I see consistently from a pattern perspective is that the city has gone to its zoning board, it's requested variances for signs, the zoning board has deemed those requests to be reasonable, and I'm not arguing whether the hardship standard was or was not applied correctly, but those signs have been approved. And so I see a pattern there that to me as a planner indicates that I should look at the sign ordinance. Now I think where Alderman Jettie and I may differ is that I completely agree with Alderman Jettie that there is a much more comprehensive look needed at the sign ordinance and the dimensional standards and the typology standards that are in there. But I also think that one thing that I've recognized in the pattern that I see here is that the municipality has indirectly been subjected to a different standard in a way. At least that's what these approvals indicate to me. I'm not suggesting for a second that the zoning board, and perhaps I did earlier and I shouldn't have done this, I'm not suggesting that the zoning board has simply said, we won't apply the hardship criteria here. I think what the zoning board has been frustrated by or had to battle against to an extent is that the fact that they're acting within the constraint of the current language of the zoning ordinance that tells them that this has to be a variance process and they must apply the hardship criteria to it. And I think that's been a challenge for them when the inherent use of the sign has been one of a public benefit. And so it's that tension that I'm recognizing only. And as a planner, acting to respond to that and provide an alternative procedural remedy that is the special exception process. The reason that I feel this is, or the justification that I find this reasonable is that the only modification this special exception process produces is the fact that the hardship criteria no longer is applied. I think Alderman Jettie and I disagree in a healthy way on whether or not that hardship criteria should be applied to a municipal sign. My position is that it should not. Alderman Jettie's position certainly is that it should be. I think those are both reasonable ways of thinking about it. I'm simply putting forward a solution that I think will provide a more consistent and predictable process for the municipality when making a request for a sign and not necessarily subjecting them to this unpredictable criteria that we've seen relieved many, many times where they have to demonstrate a level of hardship. And I'll close my comments there. I think I'm at risk of lobbying too hard for a piece of legislation, but I'm going to step back and sort of be less emotional about it. You know, I've seen some frustration on the part of staff here about how to apply these ordinances. I've certainly seen it applying for, you know, some of my own signage for things. I don't want to imply that I'm, you know, my language or my view is tainted here in any way, but I do believe this is a real problem, and I certainly respect if the committee feels that this is not the right way to solve this. I believe that it is. I'd close by saying I hope that I can get your support.
Alderman Dow.
Yeah, I just want to correct one thing. As former chairman of the Zoning Board of Adjustment here in Nashville, by your definition, Alderman Jettie, a variance should never be granted because you can't prove hardship. Hardship's the hardest thing to prove, and in many, many cases. But I can tell you that the public has had thousands of variances approved since I was on the zoning board. And to say that the city is not able to subject themselves to the same criteria, I think is definitely wrong. We may be changing the zoning, but right now, if a member of the public puts in for a variance and the zoning board agrees that it should go through, it does. And this legislation, because Mr. Sullivan and I have had discussions, is not singled out for that one sign. It's for all city signs. And we have granted sign variances for corporations here in Nashua that for much larger signs and met the criteria for a variance. So I don't think that argument should be part of this discussion. I think that what we're trying to do is to streamline the process, not take away any of the criteria that's required. So I don't buy that argument either. I think you still have to meet the requirements for the signage, even with a special exception. The only thing it's eliminating is the hardship. And I can tell you from being on the zoning board for a long, long time, the hardest thing the zoning board had to define was what the hell is hardship. And the state has even taken requirements and changed things relative to the term hardship, which Director Sullivan may or may not know, but I know that it changed over the years. So I think this is a good thing. It's making it, while still requiring the same requirements for signage, it's allowing it to be a little easier for public information signage to be passed through the ZBA.
And just
Director
Just one
Sullivan.
last comment, and I apologize for being a bit emotional with my response, but I just want to comment, and I know this is not Alderman Jetty's intent at all, but our zoning board is the most professional and educated board that I've had the opportunity to work with, and I've been doing this in several communities for a bit. And so they're very respectful. They certainly are challenged by the criteria that are laid in front of them, but I don't want to imply that they're not doing their job correctly. I mean only to say that it's challenging, and this goes beyond governmental signage. It goes to any request for a variance. It is challenging, I'm not saying it's right or wrong, to balance what may on its face be a reasonable request with the strict criteria that state law lay out. And so I think it's that they struggle with, because they're working in this sort of finite box, but they are some of the most educated and professional folks that I've had the opportunity to work with. They're just struggling against that tide.
Alderman Karen.
Thank you. Out of those, may I, to Director Sullivan, please?
Absolutely.
Thank you. Out of those 15 signs, how many of them were electronic signs that the city wanted to put up?
So of the signs that were approved, 9 of the signs had some component of an EMC, an electronic messaging center, to them.
Okay.
Now, I want to be really clear about this because that number sounds big. 9 of those 9 were all within one project, and it was the Performing Arts Center downtown. All of the other signs in other locations, or none of the other signs, I should say, had any component of electronic messaging outside of the downtown Performing Arts Center.
Follow up?
Follow up?
So, first of all, I appreciate the fact that you're trying to streamline and make it easier. My understanding in my head, and I think the problem is that we're focusing on a sign that doesn't exist yet. No, Alderman Jetty. My concern was that the city was not gonna have to go to anybody and they could put the sign up wherever they wanted. My only concern would be, and I agree with Alderman Jetty, if in previous requests by other small businesses on West, they were not allowed this type of sign, I would hope that, and I believe the zoning board does a great job, I've seen them in action, that they take all of that into consideration when and if the city does go before them for a sign. Myself, I don't think we need an electronic sign. But that being said, I'll support this to go to the full board. I still have a few concerns, but I think you kind of filled in some of the pieces that questions that I had. And one of them was that the city was not just gonna be able to put up signs wherever and whenever they wanted to. So I appreciate that. But I do understand Alderman Jetty's concern.
Yep.
I really do. Thank you.
Alderman Dowden.
Yeah, 2 things. One, I can tell you, based on my 14 years being on the Board of Aldermen in the city of Nashville, the city's not gonna put up a sign willy-nilly. Somebody has to pay for it. And it has to be for public information, or the city wouldn't put it up in the first place. The only other thing I wanted to point out, there's an electronic sign at Holman Stadium, which, by the way, belongs to the city of Nashville. Didn't that have to get a variance?
No, I don't think so.
How'd it go in then?
Alderman Dowd, what's the specific sign? I can check on it, I'm not sure.
There is an electronic sign right at the entrance to Holman Stadium on Amherst Street.
True, but that replaced the old hand.
That doesn't make any
Sign.
difference. It's an electronic sign. It's still what it needed.
So I'm happy to check on any specific signs after this meeting. I can't speak to what the process was for that specific one, so I can certainly
If you
report
could let
back.
us-
Yep, sure,
And that would be satisfactory,
that
thank
would be
you.
great. Yep.
Further comment? All right, Alderman Lopez.
Sorry, I'm not a member of the committee. I feel like I'm gonna struggle with this a little bit at the full board, because having listened to some very detailed presentations on both sides, it kind of seems like each side is contradicting itself in terms of, well, we have this established tradition of the city presenting all of its signs that have managed to be approved through the existing process for the most part, but that process isn't trustworthy for the future. And we have this board which constantly is accounting for hardship, or at least not accounting for it, if my understanding is correct, but consistently treats it the same way and still consistently approves the signs that we've needed in the past. I realize that it's different in other places, but as it's being presented tonight, it just seems like a solution in search of a problem where, sure, we can streamline the process and we can redefine how the city applies for its signs, particularly through the other processes, but that component of the ordinance doesn't seem like it's actually doing anything other than removing the concept of hardship. As it's been described, it has its own process. It's still gonna be a public transparency process. It's gonna be, subject to another body reviewing it, which is the same as we have now. I am interested in the closing of the loophole of the site plans that include signs, so that they don't have to necessarily meet the need for the sign process that we have. But it sounds like that gets worked around pretty regularly as well. I do definitely understand Alderman Jetty's perspective. If I were a couple with a picture window facing, a future landfill site, having an electronic sign facing my window would be like icing on the cake. So I will definitely be keeping my eyes out for any proposal like that I have input over. And I would encourage those residents and their aldermen to do the same. I also don't think it's fair to categorize the zoning board as not doing its job because it allows variances. I think it's a very, very austere perspective on these different boards and what we do. Like, if the laws were written to such a perfect amount, and if we had such a tremendous respect for our own personal judgment to account for every possible situation, sure, I guess we wouldn't need other bodies, but we don't. And we aren't able to write laws so that we can autopilot and not make any decisions, or amendments to those laws. So I think having bodies that are able to interpret based on criteria for variances just makes common sense. It's a check against the, I guess, as Alderman Dowd would call them, unknown unknowns. So I'm not 100% sure how I'm going to vote for the Board of Aldermen. I would just say when it's presented, if there's any discussion to those effect, I would be mindful of those contradictions, that we need to change this because it's not good enough that it causes all this stress, but it won't change anything because everything we've done in the past has been the same. That doesn't make sense to me.
Okay, the chair would like to weigh in, if I may. Although I appreciate Alderman Jetty's advocacy, I got to think to the greater public good. Now, when it comes down to the authority of boards and commissions and everything, the law that is made within these chambers is supposed to be fluid. Okay, we don't hire and pay through Public Works anybody going down Main Street picking up horse manure anymore. But that was once in the books. Modern times do happen. And speaking of modern times, it sort of reminds me of the old 70s song, Signs, Signs, Everywhere's a Sign.
Even I know that one.
Exactly.
It was before my time.
So now that I dated myself, but I look that we're living in a world of, technology and information, and people want it. They crave it, okay? And I think we've seen it in many different formats of podcasts and everything else on our phones and everything else. And yet I look at the city, and sadly, I see the periodical of the National Telegraph, now with the retirement of Dean Shalhoub. And I don't see too much local stuff in there. And if it is past tense, I mean, most of the people looking at the obituaries, they're already dead and buried by the time, if I look at the Telegraph on Sunday. And it's tragically too late to go. And yet, let's look at the other thing that you hear through the airwaves, even though I'm a satellite radio listener, but go Sirius FM, you know, but the thing is, WSMN, the Weatherhawk doesn't exist anymore. So there isn't so much local news or any other things. So how can we get the information out? What we have done as a municipality is we have combined all, and I don't want to get into this, because I first should to take a step back. I feel that Director Sullivan is looking at us. The conversation did circle around we're currently changing the zoning laws, but I get the feeling from what Director Sullivan is working on with this proposal, and your proposal, Alderman Dowd, of 2351, is a change to the zoning law that will go hand in hand, that would exist with other changes that will be done in the future. Evidently, we see the need. And again, it is within our perusal, is the power of the board to come out for the public good and to meet that particular need. So I think this is what we're doing. But I do realize, in the advocacy of Alderman Jettie, that this could somehow filter back to one address. I understand that. But what we're doing here this evening is looking globally across citywide, equally. Now, I worked in the fire station that we told people to put sprinkler systems into different structures. Yet, do you think the fire stations were sprinkled? No, they weren't until we complained about it. Now they are. Now they have alarm systems and everything. So there's always been a stretch between a municipality and the thing. And then I don't really want to avoid it too much, because this is not what Director Sullivan is asking us to do here. Again, this is something that is global within the city. But let's talk about that one particular address. Is the landfill not a commercial property? I don't see anybody living at the landfill. It's not residential. And where we spent the money to put all those divisions together. Now, I know one alderman used to work for the city equally as well, and was independently winged out to a back section of a park that used to be a horse barn and had a floor in it that, you know, send somebody upstairs so they could fall through it, you know what I mean?
Is it gonna fall over here?
Gladly, we replaced that. I mean, that thing was a fire trap. And now we have a complete modern facility. And it seems like the sign itself will go hand in hand with the modernization of this new facility. The sign will be perpendicular. It's not intended to go into anybody's picture window. It will be perpendicular to the street. And it will provide information of all those divisions, whether, you know, trash pickup is going to be done, snow removal, emergency ban effects, and other important things. Even with the other departments that have been previously negated, such as, you know, park rec, time to get your seasonal permits, renting a ball field or something like that. So I see a lot of good for this. So I'll leave it at that. I'm not going to get hung up on one particular address. I'm going to more look at this as a way of fixing the zoning. I too believe that try to prove a hardship is a legal nightmare. And so therefore, I think we're going to clearly, and by working to define it better. So, and I'll end my comments with that. Any other comment? Seeing none, I'll call for the vote. Alderman Karen,
Yes.
Alderman Timmons,
Yes.
and Alderman O'Brien votes yes. Motion carries. Okay. Unfinished business, there is none. New business resolutions, there are none. Tabled in committee, there is nothing tabled in committee. General discussion, or do you want to wait till remarks from Alderman? Let's wait till remarks from Alderman. Public comment, seeing nobody here, we'll move on to remarks from Alderman. Alderman Como.
Yes, thank you, Mr. Chair. I just wanted to thank Director Sullivan. It's been about 1.5 years now since I've been on this board. I don't think I've met anyone in the city government as knowledgeable as you are. You know, we are but mere aldermen, most of us, that don't know the ins and outs of this stuff. And I can't remember a single time I've asked you a question and you didn't at least know the basics and you would follow up with more information if necessary. But the knowledge you have about the workings of city government is second to none. And I also appreciate your patience with sitting here and answering some questions that may seem, you know, benign, but to us, they're pertinent. So I appreciate your patience with us and your breadth of knowledge. So thank you.
You're well educated, very good.
I'm gonna be making enemies, with colleagues that, you know, to keep that up.
Anytime you can get a pat on the back,
Thank you.
right? Yeah.
Thank you.
Alderman Timmons, and then Alderman Karen.
Thank you, Chair. I too like to thank Director Sullivan for the argument that clearly convinced me otherwise, though I do respect Alderman Jettie. His argument was just as compelling to me, so I don't want him to think that I wasn't listening and that I may change my mind at the full board, who knows? But I think we should move forward on this, but I see a larger picture, and I thank you, Director Sullivan, for that. As far as my colleague over here, Mr. Dow, let me just tell you one thing. Everybody know how to get to that new school. All they have to do is GPS that. With this, that's it. And
There's a school?
thank you for everything, and you too, Director Sullivan.
Alderman Karen.
Thank you. I too want to thank you, all, Director Sullivan, for coming in and also to talk about the previous permitting for the outdoor dining for the private restaurants. I think it's important that everyone is treated fairly and we move forward with this. What happens at the full board level, we won't know for 2 weeks, but it could affect. And I will certainly let those people that have asked me about the permit to call you personally. No, I'll do that. But I really appreciated the piece about the signage. Alderman Jettie and I have had a conversation about it. I'm still not up there on electronic signs for some areas, but I think that showing that city staff has to go before zoning to get a permit for signs is very important because it's above board. So how that goes at the meeting as well, we won't know. But I think a little bit of the address conversation kind of skewed some of this information that we were getting. So I appreciate that, and thank you, Alderman Jettie, for your concern for your constituents. I appreciate that.
Alderman Dowd.
And a couple of things. I have an electronic sign in my ward that I'd like to put a Abrams tank to, and that's the one that started all the laws on zoning and signs. It's the big, huge one on Amherst Street. And it's grandfathered because it was put in before all of these changes to zoning on signs. And when that action was taking place, and I was sitting here, it didn't mean that everything that was done in regards to those zoning restrictions was perfect. I agree that we're looking at the entire situation with zoning. The zoning board has a very difficult thing hearing a whole bunch of cases, and I respect them fully because I've been there. And I want to thank Director Sullivan for asking me to sponsor this legislation because it's generated a lot of conversation. But I wanted to support the people that we have in our planning department and to try to help them do their job. and do their job more effectively, so I enjoyed sponsoring this.
Good. Anybody else? Well, I too recognize Alderman Jettie and appreciate your advocacy for the residents of Ward 5. This was a tough night, 2 items on the agenda. I could have very easily myself gone with the tabling, but I understand the need, and I'm talking about the outdoor dining. I understand the need to go forward with that. But I think we could work that out in the future to be better prepared as well as we should. And with that, I thank you all for your due diligence to the good work you've done this evening. It was a tough one, and I appreciate it. Thank you. All right, Alderman Timmons, do you have a motion?
I do. Motion to adjourn.
Motion to adjourn. All those in favor signify by saying aye.
Yes.
Opposed? Nobody? And we'll call it adjourned, 8:51.
I would have voted no if I had a vote.
Yeah, for sure.